So it depends. If there's an agreement between the parties, then we can finalize the divorce in a matter of months, sometimes even as short as 2 months. Typically, even in agreed cases, though, they do take around 6 months because there is a marital settlement agreement of typically 15 some pages, which defines the financial outcome of the case. If there's children involved, there's an allocation judgment, which is like 30 pages. Which contains a tremendous amount of detail with regard to how the child is going to be raised. One's going to live with these documents for the rest of your life. Okay, you don't want to have to go back to court. So that's why you want it done right, and you want to make sure that it's done in a way that you understand exactly what you're signing off to and that you're comfortable with the result. So that's why typically to draft these documents, to negotiate with both parties, to make sure that everybody understands, everybody's on the same page, everybody agrees, nobody's going to run back to court to try and change something and waste more money over a modification that could have been done right the first time. That's why sometimes it takes a little longer than people like. People think, oh, in a month they should be divorced. But really, even if it's agreed, it often takes somewhere between 3 to 6 months. The law is that there's irreconcilable differences is the requirement for there to be a divorce, and that requires technically 6 months of separation. Now that 6 months of separation can be even, I'm in the bedroom, she's on the couch, rather I think it'd be me on the couch. But the reality is that there is these 6 months, but there's a lot of flexibility. Never have I seen a judge really inquire regarding the specifics of those 6 months. If both parties sign under oath that those 6 months have existed, then they're good to go. So the first step is to prepare what's called the petition for dissolution of marriage. Now this petition is what we call the complaint at law, right? The document that opens up the case, the lawsuits, and then once this is drafted, filed with the court, the other side is served and they have 30 days to respond to that petition. If they don't respond, then they're held in default, which means that we can get everything we're asking for in the petition in their absence of filing an answer. Now, that petition is very important to get right. Not only the facts of the case have to be spelled out explicitly, and everything that we're asking for in the case has to be stated clearly and plainly, because if we don't ask for it, we risk losing the ability to gain it in the court process. But also sometimes, and this is different than many firms, we do like to include often some of the narrative of our client in order to gain, sometimes even if it's just a negotiating tactic, a negotiating hand up in the process against the other side to make them feel maybe that they make the other side feel that they have less moral agency in the case. So with every case that we begin, we do a comprehensive client intake where we have a several-page sheet of questions that our paralegal sits down face-to-face with the client and make sure that we get every single fact that's necessary in order to prosecute the case before the court. So it's not really necessary to, come to court with a stack of documents like your marriage license or your birth certificate. None of these things are really necessary. What's necessary are the facts, the date of the marriage, the names and birth dates of your children, and then financial information is really important in these cases. There's a financial affidavit that both sides have to fill out with information of like 2 years of tax returns is a typical ask by the court, several months, like 3 months of bank statements, and any other information like debts, credit cards that speaks to the financial wherewithal of either of the parties. So mediation is really valuable in a case where both parties are positively disposed towards settlement, but there are a number of issues that are unresolved. So I had a private mediation recently that went extremely well because we had a strong mediator who knew just how to push the other side and tell her, listen, you're being unreasonable. You can fight in court for another year or 2 years and spend tens of thousands of dollars in attorney's fees fighting over these things, or we can resolve them right now and you're going to get the result that essentially you're going to get after 2 more years of fighting. So mediation can be very valuable because it can cut several steps out in a case, save both parties a lot of money. And if you have a good mediator, the mediator can really explain to both sides why it's in their best interest to give certain things up in exchange for other things that they might otherwise want to fight over for many, many months. But the mediator can make it plain what is likely to happen in the result in court. And because the mediator is a neutral person, not the lawyer of one party or the lawyer of another party, although the lawyers are really important in this process as well, the mediator can help give a real clear sense of what would be a good and fair result. and that way help bring settlement much closer. So here we explain to you in this segment of our discussion what to expect in the Illinois Divorce Court. If you have any questions, please don't hesitate to reach out for your free consultation by reaching out to KHK Family Law.